Hello, everyone. I'm very happy to share this webinar, which is part of our short course on deliberative and crowdsourced constitution making processes. And today we have the immense honor to have here with us the Professor Catherine Dupré. Indeed, so we are gonna discuss one of her latest volumes. She has produced so much in the field of comparative constitutional law, but today we're gonna talk about this book, which is a great piece of scholarship, Icelandic constitutional reform, people, processes, and politics, that was edited by Catherine and by August for Arneson. Catherine is a professor of comparative constitutional law at the University of Exeter. She has studied the processes of constitutional change reform in Hungary. She also wrote about Hungary in important newspapers like the Guardian. She has been following also the Icelandic constitutional developments since 2008, when she first visited as a guest lecturer some Icelandic universities. She's also the author of Importing the Law in a Post-Communist Transition, the Hungarian Constitutional Court and the Right to Human Dignity, and of another important book, At the Age of Dignity, Human Rights and Constitutionalism in Europe. Both these volumes have been published by ART. She's definitely one of the most interesting voices in comparative constitutional law, and that's why we thought to invite her. And I'm very happy that she immediately accepted. So this means a lot to us. Catherine, I'm also speaking on behalf of Matteo Monti, the other co-director of this course. And having said that, thanks indeed once again. I give you the floor, ready where you are.
Thank you very much, Giuseppe, and thank you everybody for joining us today online. So I'm based in the UK today. So I have prepared some slides and I can really comfortably talk for about 1 hour. I hope I don't talk that long, because I think it's quite a long time for me to talk on my own online, but we'll see how it goes. So let me try to share my slides again. We did a test and it worked, so it should work again, and I'll speak. Yeah, can I check everybody
Yes.
can see the slides? Okay, so thank you very much. Just set my timer. So thank you very much, Giuseppe, for inviting me today to join your seminar series, and thank you to Matteo as well. I haven't met you, Matteo, but thanks very much for inviting me too. So this is the idea, is that I can talk about the book, and while talking about the book, I will tell you about the Icelandic constitutional reform. So Giuseppe has already given you the title of the book. I gave you the link here, and this is the book cover, and you already seen a little bit of the book cover. So what I want to do in this talk is a little bit, tell you a little bit the story about the book, and introduce the book as part of the book launch. And I will next try to give you some context, enough of a sense of the complexity of the constitutional reform, so that we can focus the discussion on the involvement of Icelanders in this reform, because I think this is one of the main topic of interest in your seminar. And I will finish with some reflections and lessons from Iceland, and then this is where we can all take part in the reflecting on the process. So this book is a co-edited collection. It came out in 2020 with Routledge, and my co-editor was August Thor Arnason, and you can see from the dates that unfortunately he died before being able to complete the collection with me. August was a constitutional law scholar. He worked at the University of Akureyri in the north of Iceland, and he was also involved directly in the constitutional reform process by being a member of the first body that kick-started the reform. It was the Constitutional Commission working over 2010, 2011 that he was personally involved in the reform. And he contributed chapter 3 to the book, which is a chapter that positions the reform in the wider context of Icelandic constitutionalism. But as an edited collection, we had also a number of contributors, and we had, in fact, a really great cast of contributors. And I wish here to pay tribute to August Thor, who knew Icelanders and Icelandic actors, of course, much better than I did at the time, and who put this incredible cast of contributors together. So what we wanted to do with the book is give a voice to those people who had made the reform happen, to those people who had taken a key role, an active part in the reform. And we also wanted to position the reform in its wider context. So I think you should be able to see I just position your screen, I swear. The table of contents of the book. I just want you to see, to give you a sense both of the people who made the reform happen, of the contributors to the book, and of the sort of our methodological approach to the reform. So let me just talk you through quite quickly this table of contents. So we wanted to position the reform in its wider context. So we had a first paper by the current president of the Republic. And you know, he's also a legal scholar by training, and he gives a historical account of the approach of presidents of the Republic to the Icelandic constitution. Then comes the next chapter, which I wrote on behalf of August Thor, which is about the reform in the wider context of Icelandic constitutionalism. And the third element of context we wanted to give is about the financial crisis that triggered this reform in the first place. And the chapter is written here by Kristrún Heimisdóttir, who was on the front line of managing the crisis in the years 2008, 2010, something like that. So she tells about her experience of how Iceland managed the financial crisis. The main part of the book, which you can see here, is focused on the drafters and drafting processes. So this is what I will talk to you a little bit more in a little bit more detail in today. And we document here the two main bodies and the two main processes. So the role of the Constitutional Commission, which was the very first body involved in the reform of the Constitution. And the chapter is written by Björk Thorarensen. And Björk was part of the Constitutional Commission, and she is, I think, people say, the leading Icelandic scholar in constitutional matters. I think she is now, has become a Supreme Court judge in Iceland. The second body involved in the reform is perhaps the body that is best known outside Iceland, and it's the Constitutional Council, and which drafted the 2011 proposal for a new constitution. So we are very pleased that the chairwoman of this council, Salvör Nordal, agreed to contribute a chapter on the work of this council. And that's chapter 6 in the book. And chapter 7 is a discussion on the crowdsourcing of the proposal for a new constitution. So the next part of the book focuses on proposals and bills, and contains 4 chapters with the main a detailed discussion. And I think this is, in English, possibly the only one, certainly the only one I have come across, the only detailed analysis and critical analysis of the entire proposal, the 2011 proposal for a new constitution. Then we have discussions of separate bills that came out of this reform. Nothing was adopted in the end, as you know. And we have a discussion by the chairman, Paul Thorharson was the chairman of the Constitutional Committee. And in his chapter, he discusses the 3 proposals that were put together in 2016. And we have discussions of specific bills that were key in the constitutional reform. One bill on the natural resources and another bill on the environmental protection, the sort of substantive issues of the reform that were at the core of the discussion in 2016 and 2011. The last part of the book is a more a reflective part of the book, and it has 2 main chapters. One sort of critical engagement discussion here by Thorvaldur Gylfason. You might have come across his name. He was a very vocal and still is very vocal about the constitutional reform. He's a very strong advocate of the 2011 proposal for a new constitution, and he was he sat in the Constitutional Council that drafted the 2011 constitutional proposal. And the last chapter, which gives an overview of the entire reform from the perspective of a politician, is written by Prime Minister Katrin Jakobsdottir, who was not the Prime Minister at the start of the reform, as you know, but became Prime Minister along the way. And we were very happy that she agreed to remain a contributor to the collection, and that she agreed to be interviewed instead of her writing a contribution. So the chapter that we have here is an edited interview of Katrin Jakobsdottir on the constitutional reform. Let me, somehow I cannot, okay, here we are. So in terms, sorry for that, I just couldn't move my slides. So in terms of comparative methodology, I've already said a few things that I just want to come back, because we all comparatists here, I imagine, in this seminar. So what was really important is this approach to, by giving to comparative law, by giving people a voice. Lots of things have been written about the Icelandic constitutional reform, but a lot of these things were written by non-Icelanders who had limited, or so, let's say, incomplete access to what was happening. And what we wanted to do is give a voice to Icelanders who made the reform happen, and give them a voice that was not mediated, or as little mediated as possible. So we invited them to tell the story from their perspective, and of course to document. It was very important just to put together documentation on the reform, and many of them engage in sort of critical reflection over the work they did and over the overall reform in their relevant, in their respective chapters. What we also wanted to do, and hopefully this will come through in a positive way today, is give a sense of the contexts in plural and of the complexity of the reform. It was an immensely complex reform in terms of bodies involved, stages, people, and things happened along the way, and there were crises and things went wrong and all of that. So we wanted to give a sense of this complexity, and we wanted to position the reform in this longer time frame between 2009 and 2017. I will explain again how we set our dates. And in terms of law, here there are 4 main legal documents that are discussed in the book. The first is the 44 Icelandic constitution, which is the constitution in force in Iceland. Then we have Act 90/2010 on the Constitutional Assembly. I'll explain what this act is about. This is the act that provided the reform with its legislative framework. This act was repealed in 2011, I'll explain why it was repealed by another act, Act 31, 2011. And then we have in 2013 a constitutional act, so an act through which the Constitution of 1944 was revised. I'll explain. Was revised for the purpose of introducing an interim revision process, and the aim was to try to facilitate the reform process that was hitting a little bit of a war at the time. This Constitutional Act of 2013 was to be valid only until the end of the term of Parliament. So it was due to sort of be terminated at the end of April 2017. So now it has been terminated, and the 1944 Constitution is remained as it was before. So let me move now to the constitutional reform itself. So I've just chosen some pictures here to illustrate my slides. And this is one picture you may associate with the constitutional reform. Excuse me. So many people associate the reform with that. It's been known as the pots and pans revolution, and you can see why the pots and the pans here that Icelanders are hitting to express their maybe anger, frustration, sense of injustice, disagreement in the winter of 2008, 2009 against the government that had led them to such a catastrophic situation, complete collapse of the banking system in Iceland over a few days. All the pictures here, I have to say, I downloaded from the Creative Commons only. They are not my personal pictures. So, okay. So this picture, this pots and pans revolution, is what people know perhaps best, but it's not the full story of the reform. So here again, I'm trying to give you a sense of the chronology of the reform. I will not take you through it date by date, and we can see illustrated here again a picture of the Icelandic people in Reykjavik on the main square in front of that building here, which is the parliament, the Icelandic parliament. And it's again Icelanders expressing their anger and sense of injustice. But the dates here, so I have color-coded this timeline to try to give a sense of the various chronologies that were unfolding at the time. So in red, you can see the financial crisis and some of the milestones I have identified here. So the banks go bust over two days in October. Emergency Act is adopted to try to respond to this crisis. We have two referendums, which you might recall about whether Icelanders should or wanted, to pay back. I think it was the Dutch and the Brits who had, taken bank account with iSave at the time. This led to a huge judicial dispute, eventually settled in 2013. So we have a really long process of Icelandic financial crisis in the background, which is only resolved in 2013. In black and bold black are the elections. So it's the almost normal political processes going on. As a result of the so-called revolution, pots and pans revolution, the government steps down in January 2008, is replaced by an interim government. It's taking power in 1st of February. Eventually, anticipated elections are held. New election in 2013, that's the normal lifespan of parliament in Iceland. And then we have anticipated election in 2016 because of the Panama Papers crisis, and again anticipated elections in 2017. So we have over that period quite a few general elections and far more than would normally take place in Iceland for a whole range of reasons, and which have nothing to do with the reform itself. And in blue, these are the key milestones of the constitutional reform in that wider context. So this Act 90/2010, which creates the Consultative Constitutional Assembly, is adopted in June 2010, so about 2 years after the beginning after the worst part of the financial crisis. A key turning point here is the submission, or is the completion of the proposal for a new constitution in July 2011 by the Constitutional Council. So in 2011, it's a little bit complex. I'll explain again. This Constitutional Assembly has changed name and has become the Constitutional Council. I'll explain a little bit about that. 2011, they give to Parliament, they submit to Parliament their proposal for a new constitution. Parliament does not much with it, but they agree to hold a referendum in 2012 to ask Icelanders what they think they should do with that proposal in 2012. The referendum is advisory. And Icelanders in 2012 expressed their broad agreement with the proposal, but the story is a bit more complicated. In 2013, you can see we have election and we have a new parliament, a very different political configuration in parliament. The reform continues, and we have three proposed articles that are put forward to parliament before its dissolution ahead of the anticipated elections in 2016, and those proposals are not voted on. So in terms of the book, this is where we started. When we saw all of that was happening, we thought it was a good time to take stock and to get people together and to reflect on what had been done and what had not been done ahead of the anticipated election. And we organized a conference here with my co-editor in Iceland. And then many of the participants to the conference became the contributors to the book. So about the constitutional reform, key proposals came out of that. So, you know, nothing changed in the end, in the sense that the 1944 constitution was not revised at all. There was no new constitution adopted. So what people would know more about the constitutional reform in Iceland is this 2011 proposal for a new constitution that was drafted by the Constitutional Council, and that was submitted to Parliament on the 29th of July 2011. So in the book, if you are interested in that, the chapters to read are chapters 6 and chapter 10. But that isn't the only proposal that came out of the reform. So what we have then is a 2012 constitutional bill on the 16th of November, was not voted on by Parliament. So that bill in 2012 is more or less, I haven't compared the two texts, but it's more or less the full text of the 2011 proposal after it was sort of polished and improved here and there by various so-called experts, people who had more technical knowledge on constitutional law issues and drafted. But my understanding, it is like more or less the 2011 proposal for a new constitution that had been a little bit embellished and sort of edited, if you want, on the basis of technical advice. And the last set of proposal was put together and completed in 2016. So that is the sort of bill, or the bills or articles that were put forward to Parliament just before its dissolution at the end of the summer 2016. And we have three distinct articles that were meant to be added at the end of the 1944 constitution if they had been adopted, and they were not adopted. but it's interesting to see the topics. So one article was about environmental protection. Another article was about natural resources. And the last article was about direct democracy or abrogative referendum. And about those provisions, if you are interested to find out a bit more, you can read the book chapters 9, 10, and 11. The last thing I want to do here is just to flag up in terms of terminology the difference of words. So in the translating those words from Icelandic into English, we were careful to try to use words that, you know, reflected the differences. So in 2011, it's a proposal, and it's deliberately, we decided not to call it a bill, although in Icelandic there is a little bit of ambiguity here. We decided to call it a proposal to express the fact that it had been outsourced, it had been drafted by outside the Parliament of Iceland. Parliament in Iceland is the constitution making body, constitution revising body. So this proposal, this text was called the proposal. This contrasts with the bills, the constitutional bills 2012, 2016, which were texts that were drafted by a parliamentary committee. So through sort of the normal parliamentary process in terms of constitutional reforms. At the end of the day, it sort of did not make much difference because no proposal or no bill was adopted at all by Parliament. What you have here in terms of illustration, you will recognize the Icelandic flag here is the logo of the Council of the Constitution in 2011 that drafted the 2011 proposal for a new constitution. So what I want to come to now, and this is the part of the presentation that will be the longest, so maybe 20 minutes or so, if it's okay. The more detailed, it's about the involvement of Icelanders in the reform process, because that was the greatest innovation that caused the greatest excitement in Iceland and outside Iceland, and also that triggered a great level of complexity and perhaps ultimately a little bit of frustration as well. So I want to take a bit more time to explain what happened. So first of all, let me introduce you to how the constitution is reformed in Iceland. And this is under Article 79 of the Icelandic constitution. And I've reproduced the text here with the original in Icelandic for the bits, the technical bits. So let me read this together, and then I'll sort of explain the key steps. So proposals to amend or supplement this constitution may be introduced at regular as well as extraordinary sessions of Alþingi. Alþingi is the parliament. It's a monocameral parliament in Iceland with 63 MPs. If the proposal is adopted, Alþingi, so the parliament, shall immediately be dissolved and a general election held. If Alþingi then passes the resolution unchanged, it shall be confirmed by the President of the Republic and come into force as constitutional law. So here, what we see is that Parliament is in charge of the Constitution revision process. A little point of detail, but that still could become, or maybe was a very big point in the context. The terminology is about amending or supplementing. It's not about drafting a new constitution. Yeah, but people tend to think that this would apply as well in the event of Iceland adopting a new constitution. So what we have here in terms of involvement of Icelanders, we have the role of Parliament, if you want, sandwiched into two general elections. And I think this is not an atypical way of reforming the constitution, and it's a way of combining general politics and the voters and the role of parliament. What is really important is that the parliament has to be dissolved immediately, and that the resolution has to be adopted unchanged by the new parliament. So this is a way of securing a strong agreement and presumably a strong democratic legitimacy to the reform. And then the next step of the process is the normal lawmaking process in Iceland, is that the president of the republic signs on the bill that becomes law. So through the role of the president here, the people, so Icelanders are involved indirectly in the lawmaking, in the constitution making process or constitution revision process, because they get to elect their president in a direct manner. So we have quite a sophisticated way of involving Icelanders in reforming their constitution, but an indirect way of involving Icelanders in reforming the constitution. And this process has been used successfully for 7 reforms of the constitution between 1959 and 2008. And the main reform is perhaps the reform in 1995, through which the human rights provisions of the constitutions were updated. So this is the broad standard constitutional framework for reforming the constitution in Iceland. This is not, however, the framework which was used for the 2009-2017 constitutional reform. And this is why things are so complicated. So I'm just trying to, my screen is, okay. So I'm trying to, I think the slideshow is responding a little bit more slowly. So, let's see what happens there.
If you think the connection is too heavy, perhaps you could switch off the webcam. I don't know if this could help.
I don't know. I think it works, but it works. It's, let me see if I can. Sure. Yeah, I'll disconnect and see if it works.
Okay.
No, it doesn't seem to. What I will do instead, I'll give us a break, and I will, how can I say, stop sharing, and
yeah, try again, and perhaps it will work.
Yeah, and just start my camera. So this is me back, and anyway, the next screen is only text, so it gives me a break from my text a little bit. So the reform in between 2009 and 2017 did not take place within the normal constitutional framework for reform, and this is where everything starts. So it took place in a special framework that was made up by Parliament, and that was organized by this Act 90/2010, adopted in June 2010. So the idea, I think, was that because Icelanders had almost completely lost their trust in Parliament and in politicians, as you know, because of what happened in the banking crisis, that the Parliament would not be the one asked to reform the constitution, but instead that they would create a special Constitutional Assembly, it was called, given the job to draft a constitutional proposal or to revise the constitution. I think that was the main idea. And then things got complicated down the line. So in order, and the idea was that Constitutional Assembly was to be elected. There were going to be 25 elected members in this Constitutional Assembly, and it was going to draft a proposal and so on. But there were lots of complexities and uncertainty. So in order to prepare the work of this assembly, there was a first attempt to get Icelanders on board of the reform, to involve Icelanders in the reform by convening what was called a national forum in 2010. So the idea, and that is quite well known outside Iceland as well, to select completely randomly about 1,000 Icelanders and to get them to meet together, in one room for one day. And they used the biggest sports hall in Reykjavik that they had to get all these people together for one day, and to get them to reflect and to express and identify the key values that matters to them, the sort of issues that should be included in the constitution, in the reformed constitution, or would be part of the constitutional revision. So in order to organize that one-day national forum and to help prepare the work of the Constitutional Assembly, it was decided to create a constitutional commission of 7 people. So if you can imagine, chronologically, the commission started preparing in 2010, preparing in June 2010. I think the act was adopted mid-June, so the commission started late June, early July. The National Forum took place in November 2010, and then the Constitutional Council, as it had been renamed, started working in July 2011, June 2011, around that. So we have 3-step process, and a little bit of complication again down the line. So the Constitutional Assembly was to draft some, so that again wasn't very clear. They were asked to consider a range of constitutional issues, so how those issues could be redrafted or reformed. But that list was not an exhaustive list, so they could also consider other issues if they wanted to. They were not asked at any point to revise the Constitution as a whole, but this was not prohibited, so this was left open to them to do that. And they were going to be elected. They were elected, and this is another way in which Icelanders were involved, as opposed to politicians. They were elected. In November 2010. And the problem was that the elections was challenged before the Supreme Court, and the court invalidated the elections. The court invalidated the elections, so that was the bit that was not anticipated. They invalidated the elections, but on grounds of there had been some kind of procedural things had not been done totally correctly, but at no point was there any mention that the outcome of the elections was questionable, or that there had been any fraud. So we have this situation where the election were invalidated, but yet the outcome of the election is found to be perfectly okay. So what is to be done? It's a bit of a difficult question for Parliament. So Parliament decides to, I think what they did is first write to every single person who had been elected, whether they would be happy to continue as a member of the drafting body, but appointed. And I think almost everybody said yes. And then they decided to appoint formally to this constitution reforming body that could no longer be called an assembly, but that was renamed a council. And those people were appointed. So we have 25 members in this council, constitutional council, who were elected and then appointed to try to sort of overcome this issue of the elections having been challenged and validated by the Supreme Court. So that makes things a little bit complicated to tell the story. And what it does in practice is that it delays the constitution reform process. So a few months have been lost in the process. So this was the first body. This was the second body. So first involvement of Icelanders is the National Forum. Then is the Constitutional Assembly that is elected, but then technically appointed. And then what we have in 2012 is a referendum to ask Icelanders, what do you think of this proposal adopted in 2011? The referendum of 2012 is technically and could only be an advisory referendum because we are totally outside the formal constitutional framework for reforming the constitution. So the referendum could only be advisory. And although the people there in the referendum voted by and large to support the proposal, almost immediately the referendum as such is been criticized, and I think partly because of that, nothing much happened after the referendum has taken place. There were some criticism almost instantly, saying only 48% of people had voted in the referendum. So it's a really low turnout, making the legitimacy of the referendum a little bit vulnerable and weak. Other people said, well, the main question, the wording of the main question wasn't very clear, so we didn't know what, etc. So that created, it was a referendum meant to clarify the situation, which at the end, I think, created more confusion than there was at the beginning. I have to go back to my slideshow. Let me, just keeping an eye on my time. Let me see if I can go back to my slideshow for myself. Yeah, so what I want now to pause on is on the idea of the crowdsourced constitution. So the crowdsourced constitution, and you can't see my slides here, but it's question mark on crowdsourced and question mark on constitution, because I think in the Icelandic case, we had neither crowdsourcing nor a constitution because there was no new constitution adopted. So this idea of crowdsourcing, it's really strange in the Icelandic context because it arose, I think, it was popularized. I'm trying to get back to my screen. It was somehow became used almost for the first time as sort of new word in relation to the Icelandic constitutional reform. And we have an article in The Guardian that said 2012. We have an article in the New York Times. So Guardian one 2011, New York Times 2012 saying, oh, look, Iceland is crowdsourcing its constitution. But at that time, the word crowdsourcing was quite new. And the whole process was really new. And it's used almost instantly by commentators outside Iceland to explain what is happening in Iceland. It is used by some people in Iceland to say, look, we're involving the people and this is a great experiment. In practice, what happened is much more nuanced and the experience is much more mixed. And this is, I want to try to give you a sense of what happened. It's quite difficult because there is no formal record of that sort of use of digital technology to involve Icelanders in the work of the Constitutional Council. So,
Catherine, if you prefer that I could share the slides for you, so if you send the slides to me, I could help perhaps if sharing is not working.
Let me see.
I'm happy to help in any case. Okay.
Yeah, thank you very much. Let me see if I can share again, if it's better. Because, yeah, you can see them.
Yeah. It's working.
So this is my slide on crowdsourcing. So the reality was a bit more complex than crowdsourcing, than the term crowdsourcing may evoke. First, there is no word in Icelandic for crowdsourcing. It just doesn't exist. The phrases we have is here, public presentation and participation. So say in English translation here of Article 20 of the Act creating the Constitutional Assembly. So that act was very clear that the Constitutional Assembly, as it was known at the beginning, that the Constitutional Assembly was to be very open and very consultative in its drafting work, and they were very clear about that under Articles 18 and 20 in particular. What it meant in practice is that, for instance, the Constitution Council had its own interactive website that people could send in comments by emails or using Facebook, that the sort of plenary meetings of the council once a week were streamed live. And at the time, I think it was quite a novelty. So there was, I think, generally a lot of transparency and openness about what was happening in the Constitutional Council. What people submitted, the extent to which Icelanders got involved in this process is more difficult to assess. So the data I found, and we have to remember that this took part in June and July in the summer of 2011. And so people say maybe not everybody was spending, their sort of summer holiday watching what the council was doing. So in terms of figures, I found two different figures. I found one of the figure of 395 comments being sent to the council. So 395 comments being sent to the committee. But within this 395, it seems that 218 were from different people. So some people sent several times comments. So 218 Icelanders is not very many if you consider the people, 300,000 Icelanders, maybe 200,000 if you take into account the sort of adult population, perhaps, or 250, I don't know. So this gives us a sort of sense of the volume and the quantity of comments. What was also very mixed, and that is the chapter by Salvör Nordal. He was the chairwoman of the council. She said that not all the committees, so the council had 3 committees, each working on different issues, and not all the committees received the same amount of comments. So there's a difference here. And not every committee dealt with the comments received in that way in the same manner. So it's quite hard, if not impossible, to track, the actual influence from one comment submitted, let's say, to the website, to the email account of the council, to see if it had really an impact on the drafting, on the final draft. It's almost impossible. But there was participation, and there was transparency in the ways in which the Constitutional Council worked. Facebook, and that's the second point on my slide, Facebook in 2008 was only beginning to be Facebook that we know now, and I think it was a really important sort of coincidence for Iceland. It was a really important tool, communication tool in the so-called pots and pans revolution in that winter. It really helped people get together. It really helped people, have a voice. And for some commentators, it had the effect, and now we're familiar with that, of course, it had the effect of magnifying some views and some voices over other voices. And perhaps some commentators would say in Iceland, it gave a too big emphasis to this idea of reforming the constitution. So this is the sort of magnifying effect that Facebook had in this autumn to 2008, 2009. I gave you here a little bit of bibliography. It is very little I found in English on this specific crowdsourcing process. So you may know the work of Helen Landemore in the Journal of Political Philosophy, a short piece which had a really huge repercussion, although it describes a tiny part of the process. And Catherine Oddsdottir, who was on the council, also wrote a short piece published the same year in the Cambridge Journal of International and Comparative Law. At the time, I think there was some genuine enthusiasm for this idea of using digital technology for making that a greater part of, direct democracy. There was a lot of longing for so-called direct democracy. Of course, at the time, I don't think people quite realize what we know now, which are the possibilities of abuses and misuses of digital technology. But at the time, we didn't have quite that experience. And I think if I want, because I'm conscious of time, I will just spend one last slide on the tensions that this has created, and then I'll just stop and open the discussion, because I have spoken for quite a long time, and I can see people have been very good and bearing with me for so long. So
take your time, Catherine. We are really enjoying your presentation.
Yeah, thank you. Okay, so I want to elaborate a little bit on the tensions, because this was not an easy process of reform. It was originally designed to get Icelanders together, to sort of reunite, to heal some wounds, to rebuild the trust. And what it did in the end is sort of generated a lot of frustration amongst ordinary Icelanders, and also a lot of frustrations amongst people who had taken part in the process. And broadly speaking, we can see there were two types of tensions. And I think there are also types of tensions that we find in other processes of constitutional reform. So this is why I want to elaborate a little bit on what happened in Iceland. So the first tension was about, the parliament against the people. And I've put the people between quotation marks because it just means whatever, very loose concept here. And that tension came from the original tension between the formal framework under the Constitution, the formal framework for revising the Constitution, and the new framework that had been created under this Ordinary Act 2010. So under the formal framework, Parliament is in charge of the Constitution revision. Under the new framework used for the reform, it was the people, it was Icelanders. That means not Parliament. So tension comes from that sort of these two frameworks. This has led, so there was what I call a procedural gap. It's not a very good term, but a question that was not anticipated and not resolved, for which there was no answer in the Act 2010, is what to do with the 2011 constitutional proposal. So if you can imagine the situation where the parliament create this body to draft constitutional provisions to reform the constitution. So this body goes way beyond that, and they draft a whole new proposal for a new constitution, but there's no guidance about what should happen to this 2011 constitutional proposal, because it hasn't gone through the normal process, and there's no bridge to take it back into Parliament in a way that is very clearly defined by the law. The law doesn't say anything about that. So the Parliament against the people tension, it goes into a different dimension, which I think is the dimension of the constitutionality of the constitutional reform itself. And this is a big issue, I think, in Iceland. So the boundaries, it's about the boundaries of Article 79. It's about how far you can stretch those boundaries. And it was about, some people saw that certainly, about whether what happened in the so-called pots and pans revolutions, which was maybe not a revolution, but whether this could amount to a revolution so big as to justify just reforming the constitution by bypassing Article 79. Were we in those years, 2008, 2009, in the sort of constitutional moment that was, you know, as phrased by Bruce Ackerman? And some people thought yes, and some people thought no. At the end of the day, I don't think maybe there wasn't such a strong constitutional moment, or maybe not such a strong constitutional momentum, but the question was definitely raised. One sort of compromise, and I thought it was a very smart solution that was found, and that didn't work out in the end, is to adopt, so to revise the Constitution, to revise Article 79, to make it possible to create a constitutional framework, a new constitutional framework for revising the Constitution. And this was done in 2013, following the standard procedure of Article 79, to create that new constitutional framework to revise the Constitution. And that led to nothing, mainly because no bill was voted by Parliament. So that window that had opened was closed without leading to any constitutional proposal being adopted. And I think if you want to have a sort of overview of, you know, how Parliament's politicians felt over those years and how they related to the various criticism and the generally, I think, interest and commitment to involve Icelanders, I think the chapter by the Prime Minister is a good chapter to read. Katrin Jakobsdottir here, because she was in Parliament throughout the reform, and she tells about, you know, how it was. She tells about her experience and her feelings, and her sometimes a little bit of discouragement, but determination to continue the reform. So there was Parliament against the people attention. And the other tension that is often present in sort of constitutional reform, and maybe in Iceland as well, is a tension between the people, so understood here as the lay people, as the non-experts, tension between people and the experts. And it's not quite clear what experts mean here, but maybe people who know about constitutional law. And experts have been blamed by some commentators in Iceland for partly being responsible for Parliament not adopting the 2011 proposal. So what I've done is to try to track down the role of experts in the constitutional reform process in Iceland. And what we see is that, in fact, in the process itself, there is no tension, as far as I can see, but what we see is sort of collaboration throughout the process between so-called experts and people with no expertise. Again, we have to be very careful as to what it means. But for instance, right at the beginning, this 2010 Constitutional Commission, 7 people, there was no requirement of any constitutional expertise for the selection of these people, but they turned out to be, I think, 5 out of 7, you know, very, very knowledgeable in constitutional law matters. We had constitutional law scholars, we had political scientists, we had the leading Icelandic constitutional law scholars. So they were, like you would say, experts, and they were there at the beginning. And they produced a very important report that was then handed to the Constitutional Council. If you look at the 2011 Constitutional Council. So this is the assembly, and they were elected, and they were meant to be sort of, let's say, ordinary people. Definitely there were clear incompatibilities with politicians. But in fact, and there was no requirement of any kind of expertise of any sort to stand in those elections. But the 25 people who were elected and then appointed, they were highly experts, as it happened, in constitutional issues, in issues, political sciences, issues that had to do with the position of the church in Iceland. So we had here a very high proportion of people, let's say, knowledgeable, although they were not, required to have that knowledge. So we have people who are not so ordinary people. We have some of them, Icelanders said, oh, they were just celebrities because people voted for the people they knew, and not necessarily that seemed to be a major criteria. And in addition to that, those 25 people could call on ad hoc expertise on specific questions as they were developing their reflection. And they did so all along the way. So again, we have a very close, I would say, cooperation between experts and not so experts people. The 2011 proposal itself was given to a group of experts, constitutional law scholars, perhaps lawyers, to be revised and to be a little bit brushed up in terms of drafting, etc. So there was here deliberately an involvement of a group of experts at the request of Parliament after the proposal was finalized by the Constitutional Assembly. So we have a mixed picture of experts, but certainly they're there at every step of the constitutional reform process. The people themselves, what do they mean? What does it mean, people? I mean, it has meant many different things at many different points of the reform, many different, let's say, configuration of the people. So first of all, we had voters. In 2009, we have this anticipated election. So this is the voters, really important here because they bring to Parliament a new majority, the Social Democrats, and it is that government that has taken the reform, started the reform. Voters in 2013 vote for a completely different configuration, political configuration. 2016 anticipated election, 2017 anticipated election, and at no point of those elections did the voters express through supporting political parties in favor of the reform. So the voters did not, the sort of will of the people to continue the reform, if you want, was not manifest through the general elections there in 2013, clearly not 2016, 2017, despite the sort of frequent opportunities. We had the new configuration of the National Forum of 950 people, randomly selected, gathered 6th of November 2010. So this was maybe one configuration of the people. We had the Constitutional Assembly, 25 people, and again, they are perhaps not ordinary people for the reasons I've explained. And we have part of the reform process advisory referendum of 2012. So we have a whole range of configurations of the people and expressing different views of or types of views about the constitution, the constitutional reform. And here perhaps the book chapter that is more useful to read is book chapter 12 if you are interested in pursuing that. I think now I will stop my presentation. I have a couple of slides. I can go back to these slides, but I think I have definitely spoken in long enough for everybody. And I'll stop sharing my slides and I'll let Giuseppe take control
Yeah,
So
thanks indeed,
of
Catherine.
the sharing.
Thank you very much.